Under Federal Rule of Evidence 702, a qualified expert may testify in a case if the expert has specialized knowledge that would help the fact finder understand the evidence or make factual determinations. But what if an alleged expert isn't actually qualified and offers testimony that's more harmful than helpful? That was the situation before the court in Jinro America versus Secure Investments. JR International Corporation was a South Korean company involved in international commodities trading. Jinro America was JR International's U.S.-based subsidiary. According to Jinro, in 1994, it entered a contract for the purchase and sale of frozen chicken with COBBI International Food Products and Landmark Forwarding Company, which were owned by Brian Bishop. As part of the deal, Jinro agreed to advance $10 million to Landmark, and Landmark was to assign $10 million worth of Treasury securities to Jinro through Secure Investments Incorporated. By mid-1995, no chicken had been bought or sold under the agreement, and Jinro brought an action in federal court to secure repayment of its $10 million advance. When litigation revealed that there hadn't been any securities assigned to Jinro as promised, Jinro amended its complaint to allege racketeering and fraud. That was Jinro's version. But according to Bishop, the parties' chicken deal was actually a cover-up for a roll program, a highly speculative investment scheme prohibited under Korean law. Bishop claimed that Jinro wasn't happy with its profits under the roll program and brought the lawsuit to recover its $10 million investment in the scheme by pretending that the chicken contract was legitimate. The district court bifurcated the trial and focused first on whether the parties' agreement was a sham. Bishop's evidence that the contract was a cover-up included testimony from David Pelham, a private investigator and purported expert on Korean law and business practices. Pelham wasn't a lawyer, had no formal training in business or as a cultural expert, and had no personal knowledge about Jinro. Nevertheless, he testified based on newspaper articles and general personal experiences in South Korea that corruption was highly prevalent in the Korean business community, and that Korean business people were untrustworthy and unethical. He also opined that Korean banking authorities would have approved the parties' chicken agreement, but that they wouldn't have approved a roll program. Pelham's testimony plainly implied that the agreement was phony and designed to deceive the banking authorities. The jury found that the contract was a sham, and the court entered judgment against Jinro. Jinro appealed to the Ninth Circuit.